Swayam Prabha. Digital India. Educated India.
Welcome to lecture number 5 of the subject Business Law. Today's topic is discharge of a contract. I am Dr. Rama Bansal, working as Assistant Professor at Arya College, Ludhiana. This project is sponsored by DTH Swayam Prabha MHRD, New Delhi. What we are going to discuss today, that is about the discharge of contract, and in that the modes of discharge of contract. Contract discharge by agreement, by operation of law, by breach, by performance, by impossibility to perform, and by lapse of time. So let's start. First of all, we will see what is the meaning of discharge of contract. Discharge of contract means termination of the contract. That means to make the contract at end. It is totally to make the contract as null. So in formal words, if we say discharge of contract means putting an end to the contract or termination of the contract. A discharge of contract refers to the contract that is fully performed. Means when both of the parties involved into a contract have performed or they have not performed, but the contract due to some legal consequences has come to an end. That means the contract is null now, the agreement is null at the end. When this situation, this stage reaches, we call it as this is a discharge of contract. Let's see an example. A says to B, I promise to sell my bike to you for rupees 50,000. And B replied that I promise to pay rupees 50,000. So A is a promiser and B is a promisee, where A says that I want to sell my bike for rupees 50,000 and B is also ready to pay rupees 50,000 for the bike. So here the contractual relationship has been created between both of the parties, means the promiser and the promisee. So when this contractual relationship gets cancelled or get terminated, we will say this is a discharge of contract. So next, how the discharge of contract is possible. That means what are the modes available for discharge of contract. 1. The discharge of contract by agreement, discharge of contract by operation of law, discharge of contract by breach, discharge of contract by performance, by impossibility to perform, and by lapse of time. Means any contract or the obligation of the contract can be discharged by any of the mentioned modes. Let's start with the first mode, that is discharge by agreement. So when both of the parties agreed in between that we want to discharge this contract by any method, that is novation or alteration, the contract is being discharged. Let's read the lines. The right and obligations created by an agreement can be discharged without their performance by means of another agreement between the parties which provides for the extinguishment of the earlier rights and obligations. The contract here can be discharged by two ways. One is the novation, second one is alteration. So now what are these terms? First one is novation. When the existing contract is replaced by a new contract, that is the novation. When a new contract is substituted, which discharges the obligations of responsibilities of the old contract, is known as novation. That means novation is a substitution of new contract for the existing one. It means when at the place of the existing contract, a new contract is being formed, the provisions of the contract are being novated. That means this is the process of novation. And novation may occur in two ways. One, new parties substituted for the old one, in which the old parties are being substituted by the new parties. Let's take example. In old contract there were parties A and B. Now either A or B are replaced with C and D, or A is replaced with C. Means either one or both of the parties are being substituted. Second, parties may substitute new contract for the old one. That means the parties would remain same. Mr. A and Mr. B were the parties of the contract in the existing one, and in the new contract even Mr. A and Mr. B would remain the parties. But now what will change? The terms of the contract. So let's see the example. A owes money to B under a contract. It is agreed between A, B and C that B shall accept to C as his debtor instead of A. So the old debtor of Mr. A to Mr. B is at an end, and a new debt from Mr. C to Mr. B has been contracted. Here the parties have changed. Here the existing parties were A and B. Now in the novation, after the novation, the parties are Mr. C and Mr. B. That means there, in case of novation, either the parties may change or parties may remain same, but the terms of the contract may change. But this must be with the permission of, with the consent of the all the parties involved into a contract. So what are the essentials of novation? One, novation occurs with the consent of all the parties. As I have said it right now, that novation must be occurred when all the parties of the contracts are ready to do that. Let's see the example. Mr. A owes Mr. B rupees 1000 under a contract. Mr. B owes Mr. C rupees 1000. Mr. B orders Mr. A to credit Mr. C with rupees 1000 in his books, but Mr. C doesn't assent to the arrangement. That means there was no consent of Mr. C for the novation. Mr. B still owes Mr. C rupees 1000 and no new contract has been entered into. Means in this example we can clearly see that if there is no consent of any of the party involved into the contract, the novation is not possible. Second is, new contract should be enforceable at law. Means what if some terms of the contracts are being changed or the parties are being the change, so after all that novation the contract must be enforceable at law. Let's see the example. If the contract was between A and B, both were the major, they were in the age of above 18 years of age and they were capable of entering into a contract. But when the parties are changed, when the novation process is being followed, there is a new contract between Mr. A and C is a minor. So C is not allowed to enter into a contract. He don't have a capacity to enter into a contract under section 10 of Indian Contract Act 1872. That means it would affect the enforceability of the new contract. So this is not a valid novation. And last is, the new contract for old must be made before the expiry of the time of the performance. That means whatever novation is being suggested or whatever novation is being done into the contract, that must be done before the expiry of the performance. Once the time of performance has gone, no novation is possible. That means in case of valid novation, there must be consent of all the parties. The new contract formed after novation should be enforceable at law, and new contract must be done before the expiry of the performance of old contract. Second is the alteration. Alteration means changes in one or more terms of the contract. As like in case of novation, here the alteration must also be done with the consent of all the parties involved. If the consent of all the parties is not involved, the contract would become void. So when the alteration is done in the contract means it must be done with the consent of all the parties, and whatever the alteration is being done, that alteration should be regarding the change in the terms of the contract but no change of the parties, and it results into the discharge of the original contract means after alteration the original contract would be discharged and there would be a new contract. So let's see the example. If Mr. A enters into a contract with Mr. B for the supply of 1,000 bales of cotton at his warehouse on 1st July 2020. Later, both Mr. A and Mr. B agreed to postpone the date of delivery to 1st August 2020. This change amounts to alteration of the contract. As we can clearly see in this example that the date of delivery has been postponed by the consent of both the parties, that is Mr. A and Mr. B. It was postponed from 1st July 2020 to 1st August 2020. So there is an alteration to the contract, and alteration is being done with the consent of both the parties involved. So it leads to discharge of the original contract. Third under this is the rescission. Rescission is what? Rescission is if the parties of the contract agree to resign it, the original contract need not to be performed. With the mutual consent and the consideration, if both the parties are agreeing that they will resign the old contract, so the original contract would be discharged. So it need not to be performed. Basically, it is a cancellation of the contract, and the cancellation must be done by the mutual consent. Mutual consent means when both the parties are ready to resign the old contract, means original contract, and when it is with the by the aggrieved party. Aggrieved party means if there is a breach of the contract by one party has not fulfilled the terms required to perform a contract, then the other party, which would be known as the aggrieved party, can ask for the rescission of the contract, that it should be discharged. Third, by the party whose consent is not free. We all know when the consent in the contract is not free, it makes the contract the voidable. So in this case, same, when the consent is not taken freely from one party, that means the contract is voidable at the option of that party. If they want to resign the contract, the original contract would be discharged. Next, remission. Remission under section 63 of Indian Contract Act 1872 says that if any kind of lesser amount or lesser degree of performance is accepted in the original contract, that means it leads to the remission. Basically, it is a unilateral act of promising discharging at his will. Means when one of the party wants to discharge the contract at his will, this is called as remission. In England, a person cannot remit unless the fresh promise is supported by the consideration. But in India, a promise he made him it or give up a part of his claim. Let's see the example. Mr. A owed large sum of money to Mr. B. Mr. C offered to pay lesser sum in satisfaction of Mr. B's claim on Mr. A. So Mr. B accepted it. It was held that acceptance was in full satisfaction and Mr. B cannot claim balance from Mr. A after receiving payment in full satisfaction. Next is waiver. Waiver is the abandonment of the right which a person is entitled to. So, to constitute a waiver, there is no need of any agreement, no need of any consideration. On waiving the contract, on waiving the right of one party, when one party waives its rights, the other party is released from his or her obligations. Let's see the example. If Mr. A promises to paint a picture for Mr. B, then Mr. B later on forbids him to do so. Means he say there is no need to paint a picture, then Mr. A is no longer bound to perform the promise. So that means waiver leads to discharge of contract. If waiver is done by one party, the other party is automatically released from his or her obligations. Next is accord and satisfaction. So accepting and any other satisfaction other than the performance means when one party is accepting that anything else which is to his satisfaction other than the performance, that is known as accord and satisfaction. If we read these two terms separately, then the accord means the promise to accept less than what is due under the old contract, means what was due under the old contract. If something less is being accepted, it is called as accord. But if we talk about the satisfaction, satisfaction is the payment or the fulfillment of the smaller obligation. So accord is unenforceable, but if it is followed by the satisfaction, it discharges the pre-existing obligation of both of the parties. Let's see the example. Mr. A owes Mr. B rupees 1000. Mr. B agrees to accept rupees 750 in full satisfaction. That means here there is an acceptance of the less performance that was to be done in original. The agreement to pay rupees 750 is an accord, and the actual payment for rupees 750 is the satisfaction. So accord and satisfaction both leads to the discharge of the original contract. So this is the first in which we have read that the original contract can be discharged by all these ways. Second is discharge by operation of law. So operation of law means where the law enters, where the terms of the provisions of the law enters into a contract, and due to that entrance of the law, the original contract is being discharged. So how it is possible? Let's see under this. The first one is the insolvency. Insolvency, as we know, insolvent person is not insolvent person is not having the capacity to enter into a contract, and this is this makes the contract void. So the rights and liabilities of the insolvents are transferred to an officer of the court. This person is known as assignee in the presidency town and insolvency officer in case of India. So it is basically when some person becomes insolvent, so automatically the contract between the two parties gets discharged. Second, the merger. In case of merger, when there is a acceptance of a higher security in the place of the lower one, it leads to discharge of contract. It distinguishes a right by virtue of its coinciding with another and greater right in the same person. Let's see the example. Mr. A holds certain property under a lease. Subsequently, he buys that property under for which he has a lease. Now he buys that property. His right as a lessee is merged into the right of ownership now for the land now acquired. That means that means a higher security is being placed at the place of the lower security. So in this case, this is automatically discharge of contract. Third, under the operation of law is alteration. An alteration is a written contract made without the consent of the other party, which leads to discharge of the contract. If any of the party involved into the contract makes any kind of alteration without the consent of the other party, this leads to discharge of contract. But it is important here to mention that alteration should be of a material part of the contract. Now, what is the meaning of material part? Material alteration means that alteration which can affect in a significant manner the right and liabilities of the parties. In other words, if any kind of alteration is being done without the consent of other party, which can have a greater effect on the right and liability of the other party, it leads to discharge of the contract. Let's see the example. If a bill of exchange for rupees 25,000 had been altered to rupees 2,500, That means the actual amount of the bill of exchange was rupees 25,000, which was altered to rupees 2,500 without the consent of the other party. So the bill becomes bad in law and the creditor cannot even ask for a decree of rupees 2,500. So here the contract is being discharged. Reason being there was no consent of the other party in case of alteration. Fourth, under the operation of law is the death. As we all know, if any of the party is dead, so there is automatically discharge of contract. Let's read between the lines. Where the performance of a contract is required to be made in person, and the personal qualifications of the promisor are the consideration for the contract. That means where the presence of the person is important, the death of the promisor discharges to the contract. Means in all those contracts where for the performance of the contract, a presence of a person and the personal qualification of the promisor are required as a consideration. So there the contract discharge with the death of the promisor. So in other contracts, the rights and liabilities of a deceased person pass to his legal representatives. So this was the contract discharge by the operation of law. Now we move to the third one, that is discharge by breach. So now what is a breach? When any party fails to perform the obligation involved into the contract, so we say that there is a breach of contract. So this breach leads to the discharge of contract. So a breach of contract under this case may be of two types. One is the actual breach and second one is the anticipatory breach. Let's read in detail about these two types of breach. Let's start with the first, that is the actual breach. So what is the actual breach? Actual breach is done when the performance was actually due. Let's see the example. Mr. A agrees to deliver to Mr. B 20 chairs on 1st May and he fails to do so that day. There is a breach of contract by Mr. A. Means when the actual performance was due and one of the parties of the contract is not able to perform on that particular day, so this is called as actual breach. And when actual performing the contract means it was during the performance, when one party cannot perform, that is called as the actual breach. So here one party performs his part and other party alleges that it is not a proper performance. So here the breach of the condition is the essential to the main purpose of the contract, which leads to discharge of contract. And if there is a breach of only a collateral term to the contract, so here the contract is not get discharged, but it will lead to the claim for damages only. That means when there is non-performance when there is a non-performance when it was actually due, so that is called as actual breach. Second is the anticipatory breach of contract. So what is the anticipatory? When any of the party involved into the contract refused to perform before the due date of performance, this is called as anticipatory breach of contract. Basically, it is a premature destruction of the contract rather than a failure to perform it. As in case of the actual breach, the one party fails to perform on the due date. But in case of anticipatory breach, it is when the promisor refuses that he would not continue with the performance, and that is even being conveyed before the due date, that is called as anticipatory breach of contract. Let's see the example. Mr. A contracts with Mr. B on 1st January to sell 500 quintals of wheat and to deliver it on 1st May. On 15th of April, Mr. A, that is before the due date, that the due date was 1st May, but now on the 15th April, Mr. A writes to Mr. B and says that he is not going to deliver the wheat. So Mr. B may immediately treat the contract at an end and file a suit for damages without waiting till 1st May. Here the performance date was 1st May. But in this case, Mr. A on 15th of April, before the due date, just refuses that he is not going to deliver the wheat. That means he is resigning the contract. He's not willing to perform that. So in this case, Mr. B need not to wait till 1st May. That was the performance date. He can file a suit for damages even before that date. So this is called the anticipatory breach of contract. Now, what are the consequences of anticipatory breach? So, consequences of anticipatory breach says that here the whole contract can be treated as broken and the damages can be claimed, or the contract can be treated as still operative and the party can wait for the time of the performance. So, let's see the example. A singer, enters into a contract with B that he will sing every night in his club for next 6 months, and B would pay him rupees 500 for every performance. On 5th day, A willfully did not come for performance but continued his performance from 6th day. Now in this case, B has signified his acquiescence in the contents of the contract and cannot now put an end to the contract, but yes, Mr. B can claim damages from Mr. A for 5th day non-performance. That means the whole contract is being not broken. Here the damages can be claimed for the non-performance. So how these damages would be calculated or how these damages would be measured? There are few cases in this. Let's read all those cases. The repudiation of a contract is accepted and the contract is put to an end immediately, right? And the damages will be measured by the difference of the price prevailing on the date of breach and the contract price. So the difference between both these terms, I repeat, the difference of price prevailing on the date of breach and the contract price is charged as a damage. But if the contract is kept operative and subsisting, then the damages will be measured by the difference between the contract price and the price prevailing on the date fixed for performance. Okay? So when the contract and the third is when the contract is terminated, the aggrieved party may bring an action for damages for breach, but he will be bound to restore to the other party the benefits he may have received under the contract. So these are the ways, these are the things when we need to which we need to consider while measuring the damages. Next, fourth is how the contract is discharged. That is, it is discharged by impossibility of performance. Sometimes the contract becomes impossible to perform, then it is considered being discharge of contract. So there are a few conditions for the impossibility of performance. One is the impossibility must be in existence when the contract was made. It may or may not be known to the parties at that time when the contract was made, but the impossibility must exist at that time. And second is, if the performance of the contract is not possible, contract is deemed to be void and no party can claim damages for non-performance. Means if there is an impossibility of performance of the contract at present, in that case no party can claim for the damages. The only remedy available is that the contract would be the void contract. So impossibility of contract may be occurring for two reasons. For it may be of two types: initial impossibility and subsequent impossibility. So let's read about the first, that is the initial impossibility. So initial impossibility, as its name indicates, that initial impossibility was the impossibility which was there at the time of the agreement. the parties may or may not be knowing the fact that it is impossible to perform. So if such type of impossibility exists in the contract, here the agreement is void ab initio. Void ab initio means it is void from the very initial, from the very first step. So in this case, because it is a void ab initio agreement, that means no contract has come into the existence. So let's see the example. If Mr. A agrees that he would discover the treasure by magic, so this agreement is impossible to perform, and this was impossible to perform with the first stage. That means it was void ab initio. So in this case, no contract has come into the existence. Second is the subsequent impossibility. Section 50 says that if following conditions are fulfilled, it leads to subsequent impossibility. Subsequent impossibility means the contract has become impossible to perform later on. So the conditions are the act should have become impossible to perform. First, the reason of non-performance event could not be prevented by the promisor, means after even after all the trials by the promisor, means after all the willingness of the promisor to perform the contract, it is now totally impossible to perform the contract. Third, the impossibility should not be self introduced by the promisor, means the impossibility of the contract is not because of the promisor, right? So we can see the example here. A and B decided to get married, but before the fixed time of the marriage, A becomes mad. So the contract becomes void. That means when A becomes mad, there is no reason which is being given by the promisor intentionally. So it is the thing which can't be prevented by the promisor, and now it is impossible to get married with B. So all these reasons have come under the criteria of subsequent impossibility. So it leads to a void contract. A contract may become impossible of performance due to following reasons. One is the destruction of subject matter. If the main subject matter of the contract is got destructed, means the subject matter of the contracts do not exist at present, that means it is impossible to perform, and it leads to discharge of contract. And the main condition to this is the subject matter of the contract is destroyed without the fault of the parties. That means there is no fault of the parties in the destruction of the subject matter. So there is a leading case in this proving this point, that is Taylor versus Caldwell. Let's see the facts of the case. The facts of the case says that a music hall is to be given for some purpose for some specific dates, but before it was given, it got fire and the whole music hall got destroyed. Means the main the subject matter of the of the contract has got destroyed before the performance of the contract. So in that case, it was held that because the subject matter of the contract is got destructed, so it leads to discharge of contract. This may also be seen in the example. A person contracted to deliver 200 tons of potatoes from a particular field. The potatoes were destroyed by the pest, though no fault of the party. The contract was held to be discharged. So as we can see in this example, there is a destruction of subject matter, means no potatoes exist, and there is a destruction of subject matter without any fault of the party. This is a main leading condition for the destruction of subject matter. It means if the subject matter is being destructed by the promisor or by any fault of the promisor, the results would be different. So in this case, where the potatoes were destroyed by the pest without the fault of the party, the contract was held to be discharged. So the destruction of the part does not absolve the promisor from performance of the contract. Second is death or personal incapacity. where the person involved into the contract is no more, means there is a death of either of the party, or there is personal incapacity of the party to perform the contract, it leads to discharge of the contract. We can see in the example, an artist undertook to sing at a theatre on a particular day, but the artist, being too ill, could not sing on the day fixed for performance. So it was held that artist was not liable to pay damages. So the heading death or personal incapacity leads to that in case of death or in case of personal incapacity to perform the contract, no charges can be claimed from the party who could not perform due to these two reasons. Next is change of law. If there is any change of law between the date of performance and date of contract, so in that case the both parties will be discharged from the contract. Let's see the example. There was a contract to supply oil seeds, but government rendered the sale and purchase of oil seed illegal under the defense of Indian rules. So both the parties were discharged from the performance of such contract, as there was a change of law which was not in the control of both the parties. Next is non-existence or non-occurrence of a particular state of thing. Where a state of things which was the basis of the contract ceased to exist, the contract is discharged. As it is clearly mentioned here, where there is a non-occurrence of a particular thing happen, which will lead to the discharge of contract. Let's see the example. Mr. A and Miss B contract to marry each other. Before the time fixed for marriage, A goes mad. The contract becomes void. That means the actual condition of the A does not remain the same on the till the date of the performance, till the date of the marriage. Means the condition of A was not the same. That means non-existence or non-occurrence of a particular state of thing is not available till the date of performance, as A goes mad. So it leads to the validity of the contract, and the contract becomes void, and it further leads to discharge of contract. Next is declaration of war. If any kind of war being declared between the two countries, and the parties are from those two countries, so it will automatically it will automatically lead to discharge of contract. But when there is a war, for the time being the contract can be suspended till the war overs, and once the war is over, the contract can be revived and enforced at the end of the war. See the example. A merchant of London had agreed to deliver sugar at Hamburg. War broke out between England and Germany. So it was held that the contract was dissolved by the outbreak of the war. So as I already said, here can be two remedies available. Either the contract can be suspended during the war, and second, it can be revived and enforced once the war is over. So next is exceptions to performance of contract. First point under this is difficulty of performance. The contract is not discharged by the reason that, only reason that it is difficult to perform. It is more expensive to perform, or it is more burdensome to perform, or it is less profitable to perform. That means all these reasons, that means difficulty, expensiveness, burdensomeness, or the profitability, does not affect the performance of the contract. So the party of the contract has to perform that contract. Let's see the example. Mr. B agreed to supply coal within a certain time. Due to government restrictions on the transport of coal from collieries, there was a failure of delivery in time. But since coal was available in the open market from where Mr. D would have obtained it, it was not a case of impossibility of the performance. So here Mr. B can get the coal from other collieries. So it was possible to perform, yet it was difficult at that time to get the coal and to deliver it in time because of some government restrictions on the transport. But still the performance was possible. So in this case, it would not be counted as impossibility of performance. Second one is the commercial impossibility. Commercial impossibility means when the contract is impossible to performance due to some commercial reasons. The leading case in this is Hari Lakshman versus Secretary of State. The facts of the case are there was an agreement between D and P to repair certain machinery. D failed to repair the machinery due to strike of workmen. So it was held that a strike of workmen is not a sufficient reason to excuse performance. That means if the workers were on strike, if the workmen were on strike, there may be some other way to perform that repair. The person can hire some other workers to perform that. That means if there was a commercial impossibility to perform the contract, but the performance of contract was yet possible, so it would not lead to impossibility. Next is impossibility due to failure of a third person on whose work the promiser relied. That means if the promiser has made a promise on the trust of the third person and there is a fault of third person, there is a failure on the part of the third person which has made the act impossible, so even then it would not lead to impossibility of the performance. Let's see the example. B agreed to sell goods to P as and when he got the same from mills with whom he had placed orders. The mills failed to supply. There is no impossibility of performance in this contract, reason being the material can be taken from the other mills too. There were chances to get the material from the other mills. That means if the particular mill from where the order is being placed, if it is not performing on the time, the party involved into the contract should get that material from somewhere else. That means the contract was possible to perform. So this reason would not be counted as impossibility of performance. Next one is self-induced impossibility. If the promiser has some kind of situations or conditions which have induced the self-impossibility to performance, even it would not counted as the impossibility to perform. Let's see the example. For example, a promise is not discharged when his failure to perform is caused by his arrest and conviction for a crime. That means if any person is not performing, reason being he is being arrested or he is being convicted for a crime, so this would be counted as self-induced impossibility, and even in this case the impossibility of contract would not come to the contract. The parties have to perform the contract. Next is strikes, lockouts and civil disturbances. The leading case for this is of Jacob versus Credit Lyonnais, in which the facts are X agreed to supply certain goods to Y. The goods were to be procured from Pakistan. Due to riots and civil disturbances in that country, goods could not be brought. So it was held that this was no excuse for the non-performance of the contract. So in other words, in short, we can say when there are strikes or lockouts or any kind of civil disturbances between the countries or the areas from where the material is to be acquired, so even in those cases there are a few chances to get the material from some other place. So that means it would not lead to the impossibility of the contract. As we have seen in this example, the material is to be procured from Pakistan because there were some civil disturbances. The goods cannot be taken from that country, so it was not be considered as an excuse to impossibility to the non-performance of the contract. Now, what are the effects of this impossibility? If the contract is considered as impossible to perform, what are its effects? First one is contract becomes void. Section 56 subsection 1 provides that if any contract becomes void because of any of the reasons mentioned above, like there is a commercial impossibility, there is a initial impossibility, or there is some subsequent impossibility to perform, it would affect the validity of the contract, means the contract would become void. Second, the benefit to be restored. The person who has received any advantage under an agreement is bound to restore it or to make compensation for it to the person from whom he has received the benefit. Third one is compensation for non-performance, where a person has promised to do something which he knew or with reasonable diligence he might have known to be impossible or unlawful, and which the promiser did not know to be impossible or unlawful. Such promiser must make compensation to the promisee for the loss incurred. That means where a person has promised to do something and he knows that it is impossible to perform or it is unlawful, and the other party, the promiser, don't know anything about the impossibility and unlawfulness of the contract, here the promiser must compensate to the promisee for the losses incurred to him. Let's see the example. A contracts to marry B. B is already married to C. So, being forbidden by law, to which he is subject to practice polygamy, A must make compensation to B for the loss caused to her by the non-performance of his promise. Next is discharge by lapse of time. The contract is also got discharged once the time is lapsed. So the Limitation Act 1940 lays down that a contract should be performed within a specified period. Specified period means the period mentioned in the contract. When the contract was made, there was some specified period which was mentioned, or the Limitation Act 1940 itself lays down the implied period for a contract. So when there is a lapse of that time, the contract is said to be discharged. In case of non-performance, if no legal action is taken by promising within the period of limitation, he is deprived of his remedy at law. Normally what happens, a court gives the right to the person that if other party do not perform in the contract, the first party can claim for damages or can take any legal action. But if that legal action is not taken in the specified time period, or the period defined under the Limitation Act 1940, so this will deprive his remedy at the law. So let's take the example. If the time period for file a money suit in Limitation Act 1940 is 3 years, then after 3 years any party cannot take any legal action against the other party. Let's see the example. A borrowed rupees 5,000 from B and agreed to repay the loan on 31st March 2018. So A failed to repay the loan, but B did not take any legal action against A till 31st March 2021. So in this case, the period of 3 years was up to 31st March 2021, as the contract was due, the performance was due on 31st March 2018. So the Limitation Act 1940 gives the period of 3 years to take any legal action, and in this case Mr. B did not take any legal action within that 3 years period of time. So in this case later on B cannot recover the amount of loan from Mr. A as the limitation period is over. So this chart gives the different period of limitation for the enforcement of some of the important contracts. So there are description of suit, period of limitation under Limitation Act 1940, and time from which the period begins. So first is the suit for the recovery of money. If there is any suit for the recovery of money, the period allotted by the Limitation Act is 3 years, and this period starts from when the loan is made. So as in the previous example we have discussed, the loan was made on 31st March 2018, so it was due, it can be enforced only in the period of 3 years. Next is suit by surety against principal debtor. Again, the period of limitation is 3 years. So the time begins when the surety pays the creditor. Next is suit for declaration. If there is any suit regarding the matter of declaration, so the Limitation Act provides the period of 3 years, and the right to sue first accrues. The time for right to sue is first accrues. And next is suit by mortgager to redeem. If any property is being mortgaged with some mortgager, and there is a suit by the mortgager to redeem, then the time period is 30 years, and it starts when the right to redeem occurs. Next is suit to enforce payment of money secured by a mortgage. So here the period of limitation given by Limitation Act 1940 is 12 years, and this time starts when the money sued for become due. Next and last is by a landlord recover possession from a tenant. Means when any landlord, when there is any property on the rent, and the landlord wants to recover the possession from a tenant. So the period of limitation is 12 years. Means after 12 years, any property cannot be recovered by the landlord from the tenant, and this time period starts from when the tenancy is determined. Means when the person has taken the property on the rent, and this 12 years continues from them. Let's take the example. If Mr. A took the property on rent from Mr. B, that means Mr. A is a tenant and Mr. B is a landlord. So if this property is being taken on 1st January 2005, so the 12 years covers up to 1st January 2017. That means if the landlord recovers the property in this period of 12 years, the tenancy rights are there, the case can be sued. But if the period of 12 years is over, this right has been this right is not available with the landlord to sue in this ground. Last is the last way of discharge of contract is discharge by performance. If someone performs the contract, that means the contract is discharged. The performance of the contract lies in doing or causing to be done what the promisor has promised to do. That means what the promisor has promised that he will do it. If he do it on the particular time, on the specified time, the contract is discharged by performance. On the performance of the obligation undertaken by the parties, the contract is automatically discharged. Means once the obligation involved into the contracts are undertaken by the parties of the contract, it means that contract is automatically discharged. When a party has not performed his promise but offered to perform the set promise in favor of the promise, he will be deemed to have performed the promise. That means in this case we can say that if any party has not performed what that party has promised to perform, but what he or she is performing now, that is in the favor of the promisee, and this would be deemed to have performed the promise. That means it is a valid performance and would lead to discharge of the contract. And the contract is terminated. Means in this case, in case of discharge by performance, the contract would be terminated when both the parties completely perform the exact thing which they have agreed to do. That means discharge by performance is, in short, is get discharged when both of the parties completely do what they have agreed to do so. So all these are the modes through which a contract is discharged from the performance. The contract is discharged. So this is the summary what we have discussed. I will summarize in one or two lines each point. We have discussed in this lecture the modes of discharge of contract. So under the mode of discharge of contract, the first we have discussed discharge of contract by agreement, where the parties involved into the contract make some agreement into the contract, either by way of novation or by alteration or by some remission or by some rescission or accord and satisfaction. So in by all these ways, the parties to the agreement, with consent of each other, if they agrees to the new terms of the contract, the old contract automatically get discharged. Second was discharge of contract by operation of law. Under the operation of law, we have discussed, like if any person becomes insolvent, there is a death of any person, there is a change in the law of there is a change in the provisions of the law. So because of the intervention of the law into the terms of the contract, the old contracts gets terminated, means the old contracts get discharged. Discharge of contract by breach. In this we have discussed that a contract, when one party fails to perform, it is a contract by breach. So here the contract by breach happens in two ways. One is the actual breach, second one is the anticipatory breach. In the actual breach, when there is a breach before the performance, or when there is a breach during the performance of the contract, that is the actual breach. But when there is a breach before the time of the contract, before the performance of the contract, that is called as anticipatory breach. Next is discharge of contract by performance. When once the contract is being performed, we will say that there is a discharge of contract by performance. Both of the parties of the contract have performed their obligation as and when it was said and in the manner which was desired. Next is discharge of contract by impossibility. If sometimes due to some reasons the contract becomes impossible to perform, that may be the initial impossibility or the subsequent impossibility. Initial impossibility means it was when the contract was made, the impossibility reason was present even at that time. The parties may or may not know that. Subsequent impossibility means the impossibility arises after the contract is being made but before the date of performance. And in both these cases, if any kind of impossibility comes into before the date of performance, means before performing the contract, and this impossibility makes the contract discharged. And last we have discussed the discharge of contract by lapse of time. Once the lapse of time is there, the specified period, the specified time of the contract is lapsed, the contract would be said as discharge of the contract. So here the lapse of time differs from the contract to contract. As for example, in the case of money lending, the lapse of time under the Limitation Act 1940 is 3 years. So once the 3 years have gone, there is a lapse of time. So a contract can be discharged by any of the modes explained here. So in next lecture we will discuss, once the contract is discharged, what are the remedies available with the parties of the contract. So this is over for this lecture. Thank you so much.